We, the people of India, having solemnly resolved to constitute India into sovereign, socialist, secular, democratic republic, and to secure all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you.
Good evening, everyone. On behalf of Advocate on Record Aspirants Academy, I welcome each one of you to our academy. And the object of this academy is, number one, to make the AOR aspirants to be a successful AOR in their examinations. Number two, to dispel the darkness of ignorance and light the lamp of knowledge. Number three, to make this bar strong in pursuit of excellence. So these are the objects of our AOR Aspirants Academy. And we are recording this lecture series, therefore it will benefit the large number of members of the bar. What we have dealt with so far, let me give a brief introduction about those lectures also, because some of the guests or the candidates who have come for the first time, I welcome each one of you. Firstly, the lecture number 1 in the YouTube that is available with respect to what is AOR examination is all about, what is its importance, and why the purpose of the AOR examination is introduced, and what are the subjects and what are the sources, what are the books that are available to study and make a preparation. So that is there in the lecture number 1. Lecture number 2, in the video, we have stated about the practice and procedure of the Supreme Court being the first paper in the AOR examination, in which we have highlighted what are the portions, what are the syllabuses that are covered. And even in the lecture number 2 itself, we have found what are the important questions that had appeared in the last 5 years question. And then we have found out which subject is most important. For example, if a writ filed under Article 32 of the Constitution of India, if it is appeared in question number 2024, 2023, 2022 of AOR examination, if we look at all these 5 years questions, we can understand from where the questions are coming from. We can at least identify the important portions in the subjects. So by that process, we have identified that writ filed under Article 32 is most important, and it is frequently appearing in the question papers. So by that, we have selected Article 32, and we have discussed Article 32 also in the lecture number 2. I will like to give a brief outline about Article 32. Article 32 falls under Part 3 of the Constitution of India. Part 3 deals with fundamental rights. So approaching the Honorable Supreme Court under Article 32 is itself a fundamental right. So the right to move the Honorable Supreme Court for violation of any of the fundamental rights, that is considered to be the very heart and soul of the Indian Constitution. Reason is Dr. B.R. Ambedkar, under whose blessings we are all sitting here, Dr. B.R. Ambedkar in his Constituent Assembly debates, he has said, if you are asked to identify which is the most important fundamental right, I am not able to refer to any other article except Article 32. According to Dr. B.R. Ambedkar, 32 is the very heart and very soul of the Indian Constitution. So by this, we can understand the importance of Article 32. Moreover, by the interpretation by the Honorable Supreme Court, the Honorable Supreme Court in many judgments, in one of the landmark judgments, L. Chandrakumar case, 7 judges bench, in which the Honorable Supreme Court has held that Article 32 and Article 226 of the Constitution of India are the basic structures of the Constitution. So it cannot be taken away by way of Article 368, where the Parliament empowers, where the Parliament is empowered to make amendment in the Constitution, but still they cannot disturb the basic structure. So the basic structure is Article 32 and 226 of the Constitution of India. Thereafter, what we discussed in the lecture number 2 is, we have, for the first time, the scope of Article 32 has been discussed in Ramesh Thapar versus State of Madras. In that case, the preliminary objection taken by the Advocate General with respect to the maintainability of Article 32. According to the Advocate General for the State of Madras, he made a preliminary submission before the Honorable Supreme Court that if there is any infringement of the fundamental right of the petitioner, that is Ramesh Thapar, where he can approach always the Honorable High Court of Madras under Article 226 of the Constitution of India, why should he approach and burden the Honorable Supreme Court under Article 32? That was the preliminary objection made by Advocate General for the State of Madras. But, however, the Honorable Supreme Court has held, we are the custodian of the Indian Constitution. We are the protector of the fundamental rights. So, therefore, we will not shy away by citing that there is an alternative ground under 226. So, therefore, we will not entertain. That we will not say. So, scope of Article 32, they have compared why it is falling under Part 3 of the Constitution. Why not under the appellate jurisdiction like Article 132, 133 or 136, or similarly like 226? Why Article 32 is found in Part 3? So therefore, it is itself a fundamental right, and we will not give away our responsibilities to protect the citizens, fundamental rights of the citizens of this country. So therefore, the scope and expansion of Article 32 is discussed in Ramesh Thapar versus State of Madras. Thereafter, we went further by citing a case law called Charles Sobrach versus Central Jail. In that case, Honorable Justice V.R. Krishna Iyer, my lord, he has said that even the prisoners has got certain fundamental rights, though they were punished, convicted by the courts, and they are undergoing a sentence in the jail, but still they have not given a farewell to the fundamental rights, and you cannot treat them as animals. Even the prisoners are also the persons. Therefore, if there is a prisoner's rights are flouted or violated, our writs, we will issue the writ. That writ will run and break through the stone walls and iron bars to correct the wrong and restore the rule of law. See how beautifully has been explained by our honorable judges. So they have said this is what the writ under Article 32. So having considered this, then Article 32 was discussed. Article 32 of the Constitution of India has got 4 clauses. For the exam point of view with respect to AOR is concerned, we are more focus is on Article 32 Clause 1 and Article 32 Clause 2. What is Article 32 Clause 1 says? The right to move the Supreme Court. The right to move the Supreme Court by appropriate proceedings for the enforcement of fundamental rights guaranteed. So they have not used only the citizens can approach the Honorable Supreme Court. They have not said only the persons can approach the Honorable Supreme Court. They have cautiously worded by saying the right to move the Supreme Court. So who has the right to move the Supreme Court? That was the question we asked ourselves in lecture number 3. The answer is, if you look at Article 14, right to equality to every person. Article 21, right to life and personal liberty to every person. But as far as Article 19 is concerned, right of fundamental right to speech and expression only to the citizens of this country. And if you look at a right to religious denominations to have and manage their own affairs, untouchability, Article 17. But Article 17, what does it say? Untouchability in any form is forbidden. It is not either to a person or to the citizen in any form. And children, 21A, the right to education. So it covers almost persons also, companies also, and then children. So therefore, the Honorable Supreme Court has rightly said, or our forefathers have rightly coined that Article 32, that means right to move the Supreme Court. It can be by a citizen also, by a non-citizen also, even by a company also, or by children also, or by public spirited person also. So therefore, the right to move the Supreme Court. Now, by appropriate proceedings, what does it mean, the appropriate proceedings? Appropriate proceedings means the question came up before Daryu versus State of UP. That was a Constitution Bench judgment, where the Honorable Supreme Court has held that appropriate proceedings means you can find the answer in Article 32 Clause 2 itself. Because Article 32 Clause 2 says writ of habeas corpus, mandamus, prohibition, certiorari, quo warranto. Therefore, any form means it should be in the nature of habeas corpus or any other writs. That was the answer given in Daryu versus State of UP. But that aspect or that approach towards the interpretation of appropriate proceedings got changed because of the changing time. In one important case, Bandhwa Mukti Morcha, in that particular case, the Honorable Supreme Court has held even a letter written by an organization, to one of the judges of the Honorable Supreme Court, stating about inhuman conditions being undergone by the by the bonded laborers who are working in the stone quarries. The Honorable Supreme Court has held, we are not concerned with any form. We are concerned with the enforcement of fundamental rights. So therefore, a letter can be treated as a writ petition, and commission was appointed, and based on the commission, they made a report. Commission made a report stating that yes, they were undergoing inhuman conditions. They were not given proper treatment at all. So therefore, the Honorable Supreme Court in Bandhwa Mukti Morcha, they released the bonded laborers forthwith. So now the appropriate proceedings means what? In Daryu versus State of UP, they said by way of a writ. But it was diluted for the simple reason we are not concerned with any form who approaches through mandamus or through habeas corpus, through a petition accompanied by affidavit enclosed with annexures. We are not concerned with that. Because reason is, at that time, Indians were very poor, underprivileged, ignorant. They were not in a position to have access to the justice. Therefore, any public spirited person can write a letter in any form, we will entertain. Because our focus not in any form, but on the enforcement of the fundamental right. So that is how it has evolved. The concept of locus standi got diluted. Now, after saying this, after discussing all these aspects, then we had proceeded further with respect to Article 32 Clause 2. 32 Clause 2, what does it say? It talks about the Honorable Supreme Court can issue any directions or orders or in the nature of habeas corpus, mandamus, prohibition, certiorari and quo warranto. right? So this is what Article 32 Clause 2 has said. So in which we had discussed about habeas corpus. What is habeas corpus? Habeas corpus means to produce the body, and where the habeas corpus rights are originated. It is only a remedial measure. 32 Clause 2 is a remedial measure. But where is the right flowing from? Article 21. Every person has got a right to approach when there is an infringement of right to life and personal liberty, except according to the procedure established by law. So therefore, in the habeas corpus, he can file a writ of habeas corpus when there is an infringement or illegal detention. If there is an illegal detention, means what? When an authority is detaining a person, when such authority has no jurisdiction at all. So he can approach either under 32 or under 226 of the Constitution of India, and he can say that my fundamental right is violated. In case if a detainee cannot approach the Honorable Supreme Court or High Court, who can approach? Because if he is illegally detained, if he is not having access to the courts, then who can protect him or who can approach the Honorable Supreme Court? His wife or father, mother, relatives, friend, anybody can approach the Honorable Supreme Court in the writ of habeas corpus. And one more aspect is, here what is diluted is doctrine of locus standi is diluted. Because general practice before the Honorable Supreme Court is, when a person is filing a writ, the first and foremost question posed by the Honorable Supreme Court is, what is your locus? On what basis you are maintaining this petition? So everybody has to satisfy how he is aggrieved to maintain the writ petition. But exception is writ of habeas corpus. And yet another exception is public interest litigation. These are the exceptions. So far from lecture number 1, lecture number 2 and lecture number 3, whatever we have discussed, I have told you in nutshell. Now let us proceed from there. In habeas corpus petition, I would like to cite one of the beautiful judgments, that is Sunil Batra. Please take down, dear friends. If any question come from AOR examination with respect to habeas corpus, please try to write this leading case law. This is Sunil Batra 2, not 1. Sunil Batra 2 versus Delhi administration. Got reported in, Sunil Batra 2, Roman letter 2 versus Delhi administration. It is reported in the year 1918, volume 3 SEC, Supreme Court cases, page number 488. I repeat, 1980, volume 3 SEC, page number 488. It is a full bench judgment comprising of Honorable Justices Justice V.R. Krishnaiah, Justice V.R. Krishnaiah, Justice R.S. Pathak, and Honorable Justice O. Chinnappa Reddy. I repeat the names of the judges, very important. Honorable Justice V.R. Krishnaiah, Honorable Justice R.S. Pathak, Honorable Justice O. Chinnappa Reddy. Dear friends, you must understand the facts of the case here. The facts of the case is very, very crucial. Sunil Batra, he was a convict and he was undergoing a sentence for death sentence. And he addressed a letter to one of the judges of the Honorable Supreme Court. What is the content in the letter? He has said, sir, one of the inmate, one of the prisoner, along with him he is there, he is undergoing inhuman treatment by the jail warder himself, who is supposed to protect. The reason is, jail warder expecting the money, he wants to extract the money from the victim through whenever the relatives wanted to visit that person, he is demanding the money. So for want of money, the jail warder started harassing the prisoner, by which what he did, he inserted a rod like inside the anus, and it was bleeding, brutality to the core. So therefore he wanted immediate interference from the Honorable Supreme Court. The Honorable Supreme Court, shocked by looking at a letter, they treated it as a habeas corpus petition. See, a letter is treated as habeas corpus petition. Immediately, a notice was issued to state government, to the concerned officials, as well as they appointed amicus curiae. They gave a right to the amicus curiae to visit the jail premises, to interact with the victim, to find out from all the witnesses and make a report. So they visited the prison and they gave a finding that Sir Sunil Batra's friend, his name is Premchand, he was really treated very badly, and due to which the rod was inserted into the anus, it was bleeding, treatment was given in the jail hospital, but jail hospital's treatment was not up to the mark. Therefore, he was transferred to Irvine Hospital and he is undergoing a treatment there. So this was the report submitted to the honorable judges. Now the honorable judges, after finding it from the letter, to check the veracity of the letter, amicus curiae was appointed. Now they have a report, amicus curiae report also before them. Now what they have beautifully said is, I will tell you in essence, and I will take you to the relevant paragraphs also. It was written by Honorable Justice Iyer, Justice V.R. Krishna Iyer. My Lord has said, the prisoners are also the persons. They are not animals. Indian prison is within the territory of India. And territory of India is being ruled by rule of law, that is Indian Constitution. So Indian Constitution, in which the fundamental rights are guaranteed, it also applies to the prisoners. Reason is, if the prisoner is traumatized, the soul of the Constitution suffers. See how beautifully it has been said. If the prisoner's fundamental rights are infringed, traumatized, the soul of the Constitution suffers, and our writs will run and protect their rights. This is what they have said. Let me read the relevant paragraphs, because I cannot in a position to substitute what Honorable Justice Iyer has said. So to do justice, I need to read what my Lord has said. I am going to read page number 495, paragraph 5. Beautifully written. See the interpretation. The only focus before the Honorable Supreme Court is this: how to enforce the fundamental rights of the citizens. Para number 5 reads like this: prisons are built with stones of law. Prisons are built not mere stones. Prisons are built with stones of law, and so it behoves the court to insist that in the eye of law, prisoners are persons and not animals. In the eye of law, prisoners are persons, not animals, and punish the deviant guardians of the prison system, where they go berserk and defile the dignity of the human inmate. Prison houses, this is very important. Prison houses are part of Indian earth. Prison houses are part of Indian earth, and the Indian Constitution cannot be held at bay by jail officials. Indian Constitution cannot be held at bay by jail officials dressed in a little brief authority, when Part 3 is invoked by a convict. For when a prisoner is traumatized, the constitution suffers a shock. For when a prisoner is traumatized, the constitution suffers a shock. And when the court takes cognizance of such offense and violation, it does like the hound of heaven, but with unhurrying chase and unperturbed pace, deliberate speed and majestic instancy, follow the official offender and throw down the outlaw adventure. So, ultimately, the essence, what has been stated in Sunil Batra 2 is, focus is on the fundamental rights. Prisoners, they are prisoners, but they are also persons. And rule of law is very important, and you cannot violate their fundamental rights. If the officials do so, then we as a court, we will protect the fundamental rights of the prisoners. So for the habeas corpus petition, if this question comes up in your AOR examination, please write this judgment. Please write this judgment. You will impress the examiners. Very, very important. Now coming to the second writ, that is writ of mandamus. I will explain you each writ with case laws. Therefore, we can understand how the constitution is put in reality for the enforcement of the fundamental rights. I am moving on to the writ of mandamus. The word mandamus means the order, to command. Who will command? It is a command by the superior authority, that is the Honorable Supreme Court or the Honorable High Court. To whom? It's a command by the superior authority to the inferior authority. The inferior authority may be courts below, judicial authorities or quasi-judicial authorities, even the tribunals, Central Administrative Tribunal, other tribunals. So they will issue directions. An order by a court commanding a public authority, even including the government and public corporation also. For what? To do their public duty. To do a statutory duty, what is entrusted by the statutes. Or not to do certain aspects which is beyond the statute. So it is a positive command also, as well as they can give to forbear from doing something also. For example, a licensing authority who is supposed to issue a license, a licensing authority who is supposed to issue a license once we fulfill these conditions. But such authority, licensing authority, is demanding a bribe or other aspects. They are expecting something more from us. But we do not want to do so. We do not want to accept his demand. So he is treating someone indifferent from others. He is treating us differently with other aspects, with other persons. That is violation of Article 14. You give license to some people, you don't give license to me. Why are you discriminating? Why there is a violation of fundamental right of equality? Therefore, we can file a writ of mandamus directing the licensing authority to issue a license. So this is one such example. So we need to fulfill 3 conditions, dear friends. To establish or to maintain a writ of mandamus, we need to fulfill 3 conditions. First and foremost is, we must have a fundamental right. One who is filing the writ of mandamus must establish that my fundamental right is infringed, number 1. Number 2, it is infringed by an authority who has a statutory duty. So he has failed in his performance in discharge of his public duty or statutory duties. That is number 2. Number 3, only these 2 conditions are fulfilled, a writ of mandamus can be maintained against such persons. So, When there are further conditions also, mandamus would be issued under Article 32, where fundamental rights are infringed by statute or by statutory order or an executive order, non-statutory. So fundamental rights are infringed by way of a statute or by way of a statutory order or by way of an executive order. So now I gave an example with respect to positive command, where the Honorable Supreme Court can issue a direction to the licensing authority to issue license. That is a positive order. When it can be negative order, not to do, forbear from doing something. Mandamus issued restraining authority from acting under a void law. When a law is void, when a law is already struck down by the Honorable Supreme Court or the High Court, if a public officer is taking action under a law which is already struck down, there will be mandamus not to act under the void law. This is a negative command, forbearing a public officer from doing something. So this is with respect to the writ of mandamus. So I am going to give you one case law. This will be applicable for both writ of mandamus also, prohibition also, and certiorari also. Therefore, I would like to cite that case law after completing the certiorari. And this is a personal case where I have dealt with. Very interesting case. So now I am moving on to writ of prohibition. That is the third writ. What is writ of prohibition? It means, please try to understand, dear friends, whatever we are reading, it is not a burden. AOR examination is not a burden. And don't think it just like that, oh, it is an examination, we need to crack it some way or the other. Don't do that. Please, even without an AOR, still we are bound to know all these important aspects. So take it as it is a compulsive platform. AOR is a compulsive platform where we are supposed to know, where we are taking it lethargically or lightly. Now AOR examination creates a sincerity, hard work within ourselves. And see, delivering a one lecture, it takes so much time for preparation. But think about those judgments written by our honorable judges. We are not writing judgment. We are just trying to read the judgment and understand the judgment. So therefore, our work is somewhat lesser than what the honorable judges has done. So it is our respect to understand the judgment and to apply it whenever we get the cases. That is what we can pay tribute to our former judges of this honorable court. So writ of prohibition means to forbid or to stop, and it is popularly known as stay order. I will give you one example. If Central Administrative Tribunal, just an example, you have filed a petition, you have filed OA, original application, before the Central Administrative Tribunal with a prayer, whatever the prayer is. If the petitioner feels that the Central Administrative Tribunal is not following the principles of natural justice, or if the Central Administrative Tribunal is not following the procedure established by law, or they are exceeding their jurisdiction, or they don't have jurisdiction but they are exercising such jurisdiction. So under these circumstances, you can always file a writ of prohibition before the Honorable Supreme Court or before the Honorable High Court. So once you file it, what will happen? You have to establish your case. Yes, there is a patent illegality, or there is lack of jurisdiction, but it is being exercised by Central Administrative Tribunal. Once you satisfy such conditions, immediately there will be order passed staying the order. What will happen next? such petition will be transferred to the concerned court where you have filed a case, be it Honorable Supreme Court or be it Honorable High Court. So it is a writ issued by a superior court to a lower court or a tribunal forbidding it to perform an act when it exceeds its jurisdiction or acting contrary to the rules of principles of natural justice. So against whom it can lie? It can lie against the judicial authorities, quasi-judicial, or even quasi-judicial authorities like an authority acting under Customs Act or tax legislations. So now coming to the next writ, writ of certiorari. Taking it forward, the literal meaning of a writ of certiorari is to be certified or to be informed. The meaning is to be certified or to be informed. This writ is issued by a higher authority, by Supreme Court or the High Court, to a lower authority or the tribunal, ordering them either to transfer a case pending with them to itself and quash if any order passed. So one is if it is already pending, they will call for the records and that will be proceeded before the superior courts. Or if they had already passed any orders, then the superior court will call for the records and quash such order because of their fatal illegality. So the writ of scope is, the writ of certiorari will be issued when any judicial body has acted beyond its jurisdiction, which is vested upon them, acts without any authority or is unable to act properly. So now moving on to one heading under certiorari is grounds on which writ of certiorari can be issued. Grounds on which writ of certiorari can be issued. Number 1, the first ground is where there is want or excess of jurisdiction. So where there is a want or excess of jurisdiction. That means when the tribunal is exceeding the jurisdiction or it do not have jurisdiction, it needs a jurisdiction to exercise. So therefore, when there is a want or excessive jurisdiction, number 1. Number 2, when there is a violation of procedure or disregards the principles of natural justice. So what is natural justice here? The court or tribunal should be free from bias. If they have some interest, vested interest in a subject matter, they can always go for a writ of certiorari. That they had a vested interest, they were biased, therefore issue a writ of certiorari quashing such order. Number 1. Number 2, principles of natural justice is audi alteram partem. I was never heard, but order was passed. So therefore it is a violation of the principles of natural justice. You can seek in this ground also for quashing the order passed by the lower authority. The reason is the principle lying in the principles of natural justice is no man shall be a judge in his own cause. And justice number 2 is no man shall be a judge in his own cause. Justice should not only be done, but manifestly and undoubtedly seen to be done. These are the 2 underlying principles in the principles of natural justice. Now, most important question that generally appears in AOR question papers, even otherwise also we must understand, what is the difference between writ of prohibition and writ of certiorari? Sometimes we get confused with these. So writ of prohibition means, writ of prohibition, writ of certiorari are similarly in nature, but there is distinction. We must understand that. What is the similarity is, it is a writ issued by the superior authority to the inferior authority for want of jurisdiction, everything, excessive jurisdiction. But the distinguished factor is when a case is pending before the lower authority, we can approach the superior authority seeking a writ of prohibition. Therefore, the crucial aspect here is pending matter in prohibition is concerned. But as far as certiorari is concerned, writ of certiorari, if already order is passed by the lower authority and such order can be quashed by writ of certiorari. So, in prohibition means matter is pending before such authority or the tribunal. In writ of certiorari means already order is passed, therefore we are seeking the quashing of the order passed by the lower authority. One pertinent question I would like to ask myself, when case is pending before the lower court, but it has not finally been disposed of, when a case is pending before the lower court, but it has not finally been disposed of, then what is the effect? The answer is, the Supreme Court we need to approach the Honorable Supreme Court by seeking two writs. One is prohibition also, as well as certiorari also. Prohibition to prevent the court to proceed with the further case. That is a prohibition. That means we are seeking the stay. So, in the writ of certiorari, they can call for the records. Even in a pending matter, they can call for the records which had already been declared, which had already been decided. So, to put it in a very nutshell, the object of writ of prohibition is in short prevention rather than cure. It's a short prevention rather than cure. But while certiorari is used as cure. So therefore, from this what we have understand is, in the writ of prohibition, a case must be pending, but acting against the natural justice or the procedure established by law, or when there is an illegality with respect to their jurisdiction, if they are exceeding the jurisdiction or if they do not have any jurisdiction. In such a position, we can approach the Honorable Supreme Court by saying the lower authority or the tribunal, they do not have any jurisdiction, therefore kindly stay the proceedings before the lower court, and then writ of certiorari calling for the records. Even in a pending matter, they can call for the records. But if there is already a decision passed, we must ask quashing also. Right? So, pending matter prohibition, not to proceed further. In certiorari, if it is already decided, we are quashing the decision. Right? Now, let me cite a case law. This is not reported anywhere, but let me share my personal experience. This is a case where I have dealt personally before the Honorable Supreme Court along with my senior associate. This is a case, the name of the case is Emmanuel Raja versus Union of India. Emmanuel Raja versus Union of India. We have made 4 respondents as parties. Firstly, Union of India, represented by Secretary, Ministry of Defence. So, Ministry of Defence is a party number 1, respondent number 1. Respondent number 2, Lieutenant Colonel. Respondent number 3, Lieutenant Colonel, who is in charge for the service record, who maintains the record of the officer. First party is Union of India, represented by Secretary, Ministry of Defence. Second party is Lieutenant Colonel. Third party is Lieutenant Colonel representing the record officer. Number 4, Government of NCT of Delhi. Number 4, Government of NCT of Delhi through SHO, Station House Officer, Police Station, New Delhi Railway Station. Now let me tell you the facts of the case, dear friends. Emmanuel Raja, he hails from state of Tamil Nadu, a place called Sivagasi. He was working as a sepoy in the army. When a case was assigned to me, he was working as a sepoy in Kashmir battalion. So he approached us. We asked, what is your problem? He explained, sir, after summer vacation, I am supposed to join the duty. Therefore, he took a train from Chennai via Tamil Nadu Express to reach Delhi, and thereafter there is a separate train from Delhi to Kashmir. So when he was about to reach Delhi railway station, he wanted to refresh himself. So he left the bag, he left his identity card, everything. He went to washroom to refresh himself. When he came back, he lost his baggage. He could not find either his identity card or his bag. He was shocked. He himself was sepoy, protecting the mother India, but within India he was not safe. And he immediately went to the railway police station. He made a complaint. Sir, I am so and so. I lost my baggage. I lost my identity card. But I cannot be here for long because I need to catch yet another train. Therefore, I will report my duty to the superior officer. So he made a complaint. He left and he boarded Kashmir train and he reached. And he reported immediately to the superior officer, sir, I have lost my identity card. For which superior officer has said, please give it in written. So therefore, after giving it in written, they issued a new identity card. This is what happened. After almost 1 year, all of a sudden, Emmanuel Raja was called to the court of inquiry. He was presented before there. He was forcibly asked to sign on blank papers. Thereafter, he was put in jail for 28 days, rigorous imprisonment. He could not understand what is happening with him, for what they are putting him behind the bars, for what purpose he was given rigorous imprisonment for 28 days, and there was loss of income also, and there was a red mark in his record service also. He was completely unaware. Therefore, he approached us. So, it is a clear case. For example, when a person is supposed to be arrested, he must be informed about what was the reason behind his arrest. And there must be a charge sheet must be provided to him to explain what is his defense. Nothing was given. Directly he was put behind the bars. So, it is a gross violation of Article 21 of the Constitution of India. And no procedure followed. So, we filed straight away Article 32 petition before the Honorable Supreme Court. Though we had in our mind, can we file before High Court of Kashmir or before Delhi or before Tamil Nadu? Since all these are involving and concerning the fundamental right of a citizen of this country, we filed Article 32. It was filed, it came up before the Honorable Judges, and our foremost ground was violation of Article 21. No procedure was followed. Even under Army Act, there are certain procedures to be followed, which was not followed at all. Thereafter, notice was issued immediately to all the opposite parties, that is the respondents, Ministry of Defence and others. But very fairly, this is the point to be noted, it was not contested. Very fairly, AAG, Additional Solicitor General, had fairly stated, yes, there are certain violations of the fundamental rights. So therefore, your lordships may consider. So what was our prayer? In our writ, we asked for writ of certiorari because it was not pending. Therefore, we were not available with the writ of prohibition. Order was passed. Therefore, the writ of certiorari calling for the records, which culminated into passing the order of imprisonment for 28 days. So we asked for writ of certiorari. We asked for writ of mandamus also. Since no procedures were followed, command, direct the concerned officers to compensate for our illegal detention. We were compensated. I will not say how much. We were compensated and it was disposed of. So this is a classic case for mandamus also, because generally in writ compensation is not issued general, but there are exceptions. You can ask questions later. There are certain exceptions in which, in this case, a gross violation of a fundamental right. So therefore compensation was given and certiorari was also issued. It was ultimately allowed. This was my personal experience. See, it is not something that we always need to write a reported judgment. The examiners, what do they expect is whether this candidate has understood the basic concept. Even if you had filed your own cases, you can cite the name of the case. And my personal experience, I have personally involved in this case where I have fought this case before the Honorable Supreme Court. This is the facts. This is the issue. For SLP, you can cite your own case. They do not exactly want what is there in the rule book. What are they expecting is whether this person has got some maturity, responsibility and accountability, because we are practicing the highest court of the land. Ultimately, there is no further appeal except review and curative petitions. So therefore, that is what expected from the AOR is concerned. Now moving on to the writ of quo warranto. And if we take in Emmanuel case, for example, Emmanuel Raja was in jail. If wife or the daughter or the son, if they are unable to reach Emmanuel Raja, if they are unable to contact him, then they can always approach us and ask for a writ of habeas corpus also. So when we reach the court, that determines what weapon we use. Either writ of habeas corpus, writ of prohibition, writ of certiorari. So hope the concept of all these writs are clear. Now moving on to writ of quo warranto. A writ of quo warranto can be claimed by a person, any person, if he satisfies the Honorable Court that the office in question is a public office. The office in question is a public office. And number two is if it is held by a person without legal authority. So there is a public office where to occupy the chair, he need to fulfill certain qualifications. If he doesn't have such qualifications and he is occupying the post, a particular post, then we can always challenge on what authority he is holding the public office. Please question him. Who can file it? The Vice Chancellor of a university is appointed. According to me, he doesn't have proper qualification. So I file a writ under Article 32. Whether locus is to be tested? The answer is no. Anybody can file a writ of quo warranto and challenge his authority on what basis he is occupying the post. So this is the conditions, dear friends. Now let us see a very latest judgment passed by the Honorable Supreme Court with respect to writ of quo warranto. I will tell you the citation first. 2022. This case is reported in 2022, Volume 5 SEC, page number 179. I repeat, 2022, Volume 5 SEC, page number 179. What is the name of the case? Gambhir. I spell the name. Gambhir. Gambhir then K. Gandhi. Gambhir then K. Gandhi versus State of Gujarat and others. I spell the name once again, dear friends. Gambhir Dan. Gambhir then versus State of Gujarat and others. It is a judgment, a bench comprising of Honorable Justices, Honorable Justice Emma Shah and Honorable Justice B.V. Naharatna. These are the two honorable judges who delivered this judgment. What is this case about? Gambhir then has filed a writ of quo warranto. Challenging what? Challenging the appointment of Vice Chancellor. Vice Chancellor has arrived as respondent number 4. So he has challenged the appointment of Vice Chancellor in Sardar Patel University, SP University, Gujarat. Sardar Patel University, Gujarat. On what ground? What are his challenges? Challenging the appointment. First prayer is challenging the appointment of respondent number 1 as a Vice Chancellor of respondent number 2, that is Sardar Patel University. Respondent number 2 is the university. Respondent number 4 was the Vice Chancellor. So he is seeking a writ of quo warranto. What is the second prayer? The second prayer is to quash and set aside the notification dated 29th August 2019. Set aside the notification dated 29th August 2019 passed by respondent number 1, that is State of Gujarat, appointing respondent number 4 as the Vice Chancellor of the respondent SP University. So there is a notification by which respondent number 4, that is Vice Chancellor, was appointed. So we are here, the petitioner sought the quashing of the notification. Therefore, his appointment goes. Number 3, the third prayer is also prayed for any other appropriate writ, direction or order. If you look at Article 32, Clause 2, it speaks any orders, any directions or so writ, direction and order directing respondent authorities. Who are the respondent authorities? State of Gujarat, University also, to recover from respondent number 4. To recover from respondent number 4, that is the Vice Chancellor whose appointment under challenge, all consequential benefits, whatever the benefits that he have enjoyed, that has to be recovered. So this was the prayer. Now what did Honorable Supreme Court has said? I would like to read few paragraphs and I will explain. Writ of quo warranto was allowed. And they said, yes, he has not appointed properly. So therefore, they wanted the State of Gujarat to make the selection process properly. Therefore, appoint the Vice Chancellor, the right person, not through any other means. Because Vice Chancellor, who is he? He is the head of the university. He is the link between the university and the public students. And whatever he preaches, he has to follow first. So therefore, how beautifully it was, the author of the judgment is Honorable Justice Emma Shah. And I would like to refer to some of his paragraphs. Para 51. Para 51 is the ultimate finding of the Honorable Supreme Court. In view of the above discussion, and for reasons stated above, the appointment of respondent number 4 as Vice Chancellor of the Sardar Patel University, respondent number 2 herein, is contrary to the UGC provisions. namely UGC Regulations 2018. We hence allow the present writ petition and issue a writ of quo warranto, quashing and setting aside the appointment of respondent number 4 as the Vice Chancellor of SP University. The present petition is accordingly allowed. So this is what ultimately they have succeeded. But while discussing this, there are few important paragraphs where we need to record it. Para 55. Discussing the situation in the backdrop of principle of governance as quoted by Chanakya in his Niti Shastra, Yatha Raja Tatha Praja. The sense of morality must begin from the door of the leader who preaches it. So therefore, it is not preaching, you should also practice. 56, para 56 is, I'll read 3 paragraphs, dear friends. Para 56, thus, universities are autonomous and the Vice Chancellor is the leader of a higher education institution. As per the norm, he should be an eminent academician, excellent administrator, and also someone who has a high moral stature. The aforesaid reports of the Radhakrishnan Commission, Kothari Commission, Nanam Commission, and Ramlal Parik Committee have highlighted the importance of the role of Vice Chancellor in maintaining the quality and relevance of universities in addition to its growth and development, keeping in view the much needed changes from time to time. Further, these committees have also made suggestions and recommendations for identifying the right person for the said position. At this stage, it is correct to say that a Vice Chancellor is the kingpin of the university's system, very chief role, very important role, and a keeper of the university's conscience. That is what para 56 says. There is one more paragraph, para 57. Further, in our view, that is in the view of the Honorable Supreme Court, the selection committee plays a vital and significant role in the selection of the Vice Chancellor. Yet, the selected Vice Chancellor's performance in the universities vary from university to university. Therefore, the members of the search committee who are given the privilege and honor of selecting and suggesting names for the appointment of Vice Chancellor are directly or indirectly responsible for the achievement of the university, commitment to the quality and the objectives of the universities in particular and higher education system in general are of course the deciding factors in selecting the right person. The last paragraph, we are sure, the last paragraph, para number 58, we are sure and we hope and trust that while making a fresh appointment of Vice Chancellor in the state and the universities thereunder, the aforesaid aspects shall be kept in mind by the state and the universities concerned. With this hope and trust, we leave the matter there. So with this, dear friends, we have successfully covered all the writs under Article 32 Clause 1 also, 32 Clause 2 also, with decided case laws. So we have broadly covered the entire aspects. Now our next session would be, we will select one question from the AOR examination and how to answer those questions. If it is 20 marks, I will be answering how to present. If it is 5 marks, how to present. Because whatever we prepare, that is important. But more than that, how are we going to deliver within 3 hours what is the hard work that we have done for the 1 year or for almost 4 years, 5 years rather. So therefore, the presentation is more important. So my object is, the AOR Aspirants Academy object is, first to make sure that AOR Aspirants understands the basic concept of what is mentioned in the syllabus. Thereafter, how to address each question, that we will take up one by one questions from 2024, we will proceed on to 2023, and we will select one or two questions that will be circulated in our group. Therefore, you can also come out with certain preparation. I will share my experience and we can have a collective discussion also. So with this, I am more privileged and honored to share my knowledge with you all for the patience hearing. Thank you so much. Give us more support. We will grow together and making strong war that is good for the system also, good for the litigants also, because we all exist for delivering of justice, speedy justice, timely justice, quality justice. Thank you so much. Thank you.
I came here specifically because I want to encourage Mr. Raja. He is my younger brother. He is a great lawyer and he has very great future. He will guide you all, including me and seniors also. He learns from the seniors, learns from the juniors, learns from also the litigants. So he is a common man's lawyer and he is very humble, very honest, very competent. So he will guide you not as becoming only AOR, become a good lawyer, good person also. You follow him from A to Z, you will become a good person, you will become a good lawyer, good AOR, and what he says, not only what he said you follow, you also question him, he will also cross-question you. So the movement will go on. For quality justice, for morality, for competency, for excellency, he is one of the iconic lawyers. I tell you, his height is small, but he speaks very nice things. I heard him otherwise, but I specifically ensured today that I should hear him by person. I will ensure that all of my followers, all of my good lawyers, younger or seniors, they should come to him. So he is a nice person, you are at the right place. Whether you become advocate record or not, whether you still pursue that profession or not, but whatever you learn from this gallery, it will be immense value in the future to become a good lawyer, good human being, and it will contribute immensely to the system. Thank you, Raja. He is doing wonderful job, noble job. My blessings and all the good wishes for him always. Thank you. Thank you.